takip eden izleyicilerimiz. Bu sabahki programımızın ilk oturumuna hoş geldiniz. Herkes için verimli bir gün olmasını temenni ediyoruz. Bu oturumda Sayın Doçent Doktor Gamze Tuğra Başar'a, Sayın Doktor Fatma Esenyel Hanaz, Sayın Araştırma Görevlisi Ecem Kirkit, Sayın Profesör Doktor Hayru Nisa Özdemir tebliğlerini sunacak olup, Sayın Profesör Doktor Sahibe Oktay Özdemir oturuma başkanlık edecektir. Sayın Başkanım, oturumu yönetmek üzere sözü size bırakıyorum.
Çok teşekkür ederim hocam. Öncelikle tabii böylesine kapsamlı bir toplantının hazırlanmasında ve bizlerin de burada bulunmasında emeği geçen herkese, vesile olan herkese teşekkür etmek istiyorum. Kişisel verilerin işlenmesinde çocuğun rızasının geçerliliği meselesini ele alacağım bugün. Tabii günümüzde cep telefonları...
Consent of the children in the processing of personal data. We do have tablets, mobile phones, and everybody has an access, easy access to internet, and this is an online society, therefore analyzing, processing, and storing personal data has become easier when you compare it with the past. And personal data processing activities that the children do themselves. Apart from that, the parents are sharing, let's say, the ultrasound images of the baby in the womb of the mother. We see them and processed in the digital platform, and because of the sharing, the parents are violating the fundamental rights of their children, let alone protecting them. And the children need to be protected against their parents, you know. After me, you know, next speaker is going to be talking about that. Children born in digital era, they are socializing online, and in the world, 1 out of 3 internet users is under the age of 18, and it's clear that personal data of children are processed a lot. It might be because of private reasons or public reasons. When they're asleep, for example, there are security cameras or smart toys. These children are being watched, and they're being analyzed and finally manipulated. So our priority is to have a shield for the children, because children are prone to hazardous materials and everything, and it's important to protect their rights. And they don't have any consent. And what are the rights of the children? And they don't have the awareness about their rights. Therefore, there should be a special regulation for the protection of the personal data and the consent which is required to process the personal data should be taken, but how from the children? In Turkish code, when we look at the legislation about personal data protection, there is no special regulation about the children's personal data. For this reason, the open consent, which is stated in the code, how is it going to be taken from the child? If the child gives consent, is it going to be valid? And we are going to be we are going to try to give answers to that with the custody and the other concepts. And the minor, they don't have the ability to discriminate, you know, when you take the consent of the children. We need to evaluate that. That authority, having the capacity, we need to be looking at that. And limited capacity group, we need to make that categorization, and then we will look for answers for the questions. Capacity to discriminate is to understand the actions and the results out of that action. And when we look at the third article of the Civil Code, it is important, and the factors are being expressed under that article, being minor under the age of 18, but of course it is parallel to the age. In the Civil Code, it doesn't say any limitation of age. Therefore, the age of the minor, we are looking at the characteristics of the concrete event. When we look at the 15th article of the Civil Code, as stated here, those who don't have capacity to discriminate, to perceive their actions, don't result in legal sanctions. And in terms of children, you know, these people cannot use their rights, because right to give